Hi, and welcome to What's the Tea in L&E. I'm Leah.
I'm Emily.
And we are management side employment attorneys with Rogers Vandeventer Black. And today we're going to be talking about a recent change to the religious accommodation standard in the workplace. Emily, where did this change come about?
The Supreme Court heard a case this summer brought by Mr. Gerald Groff. Mr. Groff is an evangelical Christian, and he worked for the United States Postal Service, which for many years didn't involve work on Sundays. But at some point, the U.S. Postal Service began contracting with Amazon, and so they needed their workers to work Sundays, which caused a problem for Mr. Groff and his religious beliefs.
But we need those prime shipments to arrive on time.
That's right, 2-day shipping does not happen on its own.
No.
Well, sometimes Mr. Groff could find co-workers to switch with him for his Sunday shifts, but sometimes he couldn't. And when he didn't come into work. So eventually he was terminated, and then he brought this case. And the Supreme Court actually said that the standard for evaluating whether someone's religious accommodation request is reasonable has changed a bit.
Yeah, it used to be that an employer would only have to show, they could basically deny a religious accommodation by only showing that it was a de minimis burden. So just a little bit of a burden on the organization. But now the Supreme Court has said, no, you've got to be able to show it is a substantial burden. So essentially a really undue hardship. And it's kind of interesting when you think about that.
What are some ways that businesses could prove a substantial burden, Leah?
So a couple of different things, right? You want to actually be able to sit there if you're an employer and think about, if I were on the witness stand, how would I prove this, okay? It's got to be more than just, hey, that's not fair to the rest of the workers. So I would look at things like your operational needs. Are you missing out on fulfilling those contract obligations with Amazon, for instance, if you don't have people to schedule? Are you having to schedule other employees to fill that shift, and now you're paying an increased premium in terms of overtime?
Yeah.
So look at finances and the impact. Look at hiring needs. And yeah, you can talk about something like morale and fairness to the rest of the workers. So that being said, what should employers do in the meantime now that the standard has changed?
Well, you're going to want to train managers and train your HR personnel about the new standard. They're going to want to treat this more like an ADA accommodation in the future. And you should probably update your policies and procedures. This is a very nuanced and new area of law. So if you have any questions about that, please reach out to the attorneys at WRVB. We'd be happy to help you do that.
Yep, and document. Engage in that interactive process with the employee. Make sure you're documenting as much as you can your efforts and attempts to try to accommodate their religious needs and their ability to exercise their religion, but also documenting the burden and the impact on the organization throughout the process.
Absolutely.
So thank you for joining us, and we hope you join us next time
For What's the Tea?